Hello, my name is Kathy Norton, and I am with JER HR Group. We are proud to be your organization's human resource consultants. I'm pleased to be presenting this video to ensure that each of you are properly trained on sexual harassment prevention. The term sexual harassment may mean different things to different people depending on your life experience. That is why we are here today. Certain conduct may seem acceptable or have seemed accepted in the past. This does not mean it is acceptable to people we work with today. The purpose of this training is to set forth a common understanding about what is and what is not acceptable in our workplace. New York State and New York City have long been committed to ensuring that all individuals have an equal opportunity to enjoy a fair, safe, and productive work environment. Laws and policies help ensure that diversity is respected and that everyone can enjoy the privileges of working in New York. Preventing sexual harassment is critical to our continued success. Sexual harassment, or harassment of any form, will not be tolerated. It really is that simple. This means any harassing behavior will be investigated, and the offender or the offenders will be told to stop. It also means that disciplinary action may be taken if appropriate. If the behavior is sufficiently serious, disciplinary action may include termination. Repeated behavior, especially after an employee has been told to stop, is particularly serious and will be dealt with accordingly. This interactive training will help you better understand what is considered sexual harassment. It will also show you how to report harassment in our workplace, as well as your options for reporting workplace sexual harassment to external state and federal agencies that enforce anti-discrimination laws. These reports will be taken seriously and promptly investigated, with effective remedial action taken where appropriate. After this presentation, you will watch a case study video and answer questions based on the presentation. You will also have an opportunity to ask questions at the end and will receive a reply within 2 business days. We hope you enjoy the training. Let's get started. What is sexual harassment? Sexual harassment is a form of sex discrimination and is unlawful under federal, state, and local laws. Sexual harassment includes harassment on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. Sexual harassment includes unwelcome conduct which is either of a sexual nature or which is directed at an individual because of that individual's sex, when such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment, even if the reporting individual is not the intended target of the sexual harassment. Such conduct is either made explicitly or implicitly a term or condition of employment, or submission to or rejection of such conduct is used as the basis for employment decision affecting an individual's employment. There are 2 main types of sexual harassment. A hostile work environment. A hostile environment on the basis of sex may be created by any action previously described, in addition to unwanted words, signs, jokes, pranks, intimidation, physical acts, violence, either of a sexual nature or not of a sexual nature, directed at an individual because of that individual's sex. Hostile environment sexual harassment can include sexual or discriminatory displays or publications anywhere in the workplace, such as displaying pictures on walls, posters, calendars, promotional material, reading material, or any other materials that are sexually demeaning or pornographic. This includes sexual displays on workplace computers, screensavers, cell phones, and sharing such displays while in the workplace. Also included in this category can be sexually oriented gestures, noises, remarks, jokes, comments, anything about a person's sexuality or sexual experience. Included in a hostile work environment are hostile actions. These actions are taken against an individual because of that individual's sex, such as rape, sexual battery, molestation, or any attempts to commit these assaults. But they can also be physical acts of sexual nature, including, but not only limited to, touching, pinching, patting, grabbing, brushing up against another employee, poking at them, interfering with or destroying a person's workstation, tools, equipment, or interfering with that person's ability to perform their job, sabotaging an individual's work, bullying, yelling, name calling. All of this can be brought into a hostile work environment. Quid pro quo sexual harassment occurs when a person in authority trades or tries to trade job benefits for sexual favors. Quid pro quo is a legal term meaning a trade. This type of harassment occurs between an employee and someone with authority. It could be the owner of the company, CEO, supervisor, manager, anyone who has the ability to grant or withhold job benefits. Quid pro quo sexual harassment also includes offering or granting better working conditions in exchange for a sexual relationship, threatening adverse working conditions like demotions, shift alterations, or work location changes, denial of opportunities if a sexual relationship is refused, could involve using pressure, threats, or physical acts to force a sexual relationship, or retaliating for refusing to engage in a sexual relationship. Let's move on and talk about who can be the target of sexual harassment. And the reality is, sexual harassment can come between any individual, regardless of their sex or gender. New York law protects employees, paid or unpaid interns, non-employees, including independent contractors, and those employed by companies contracting to provide services in the workplace. Who can be the perpetrator? Again, pretty much anyone in the workplace. The harasser can be a coworker of the recipient. The harasser can be a supervisor or manager. The harasser can be a third party, including a non-employee, intern, vendor, building security, client, customer, or visitor. Basically, anyone who's at the workplace. Where can sexual harassment occur? Harassment can occur whenever and wherever employees are fulfilling their work responsibilities, including in the field, at employer-sponsored events, trainings, conferences open to the public, office parties. Employee interactions during non-work hours, such as at a hotel while traveling or at events afterwards, can have an impact in the workplace. Locations off-site and off-hour activities can also be considered extensions of the work environment. Employees can be the target of sexual harassment through calls, texts, email, social media. Harassing behavior that in any way affects the work environment is rightly the concern of management. So we're going to move into sex stereotyping now. Sex stereotyping occurs when conduct or personality traits are considered inappropriate simply because they may not conform with the other person's ideas or perceptions about how individuals of either sex should act or look. Harassing a person because that person does not conform to gender stereotypes or to appropriate looks, speech, personality, or lifestyle is sexual harassment. Harassment because someone is performing a job that is usually performed or was performed in the past, mostly by persons of a different sex, is sex discrimination and sex stereotyping. At this point, let's review what we've covered so far. We discussed what constitutes sexual harassment, the different ways it can show up in the workplace, who could be the target, who could be the offender, where it can occur, and the concept of sex stereotyping. We're now going to discuss what happens when sexual harassment has been reported or observed, as well as what are the supervisory responsibilities. Let's begin by talking about retaliation. Any employee who has engaged in protected activity is protected by law from being retaliated against because of that protected activity. Protected activity with regard to harassment includes making a complaint to a supervisor, manager, or other person designated by your employer to receive complaints, making a report of suspected harassment, even if you are not the target of harassment, filing a formal complaint, opposing discrimination, assisting another employee who is complaining of harassment, providing information during a workplace investigation, or testifying in connection with a complaint filed with a government agency or in court. Retaliation is any action taken to alter an employee's terms and conditions of employment, such as a demotion, a harmful work schedule, a location change, a reduction in wages, because that individual engaged in any of the discussed protected activities. Such individuals should expect to be free from any negative actions by supervisors, managers, or the employer motivated by these protected activities. Retaliation can be any such adverse action taken by the employer against the employee that could have the effect of discouraging another reasonable worker from making a complaint about harassment or discrimination. The negative action need not be job related. It may not even occur in the workplace. It could occur after employment, such as giving an unwarranted negative reference. It's important to understand what is not retaliation as well. A negative employment action is not retaliatory merely because it occurs after the employee engages in the protected activity. Employees continue to be subject to all job requirements and disciplinary rules after having engaged in such activity. Supervisors and managers are held to a high standard of behavior. This is because they are placed in a position of authority by the employer and must not abuse that authority. Their actions can create liability for the employer without the employer having any opportunity to correct the harassment. They are required to report any harassment that is reported to them or for which they have observed. They are responsible for harassment or discrimination that they should have known about with reasonable care and attention to the workplace for which they are responsible. They are expected to model appropriate workplace behavior. Supervisors must report any harassment that they observe or know of, even if no one is objecting to it. If a supervisor or manager receives a report of harassment or is otherwise aware of it, it must be promptly reported, without exception, to the employer. Even if the supervisor or manager thinks the conduct is trivial, even if the harassed individual asks that it not be reported. They are responsible for knowing about it, and they are subject to discipline for failing to report any suspected sexual harassment or otherwise knowingly allowing sexual harassment to continue. Supervisors and managers will also be subject to discipline for engaging in any type of retaliation. We cannot stop harassment in the workplace unless management knows about it, and this is everyone's responsibility. You are encouraged to report harassment to a supervisor, manager, or anyone else in authority, or anyone you feel comfortable with, so the company can take action. Remember, behavior does not need to be in violation of the law to be in violation of company policy. We will provide you with a complaint form for the report. But if you are more comfortable reporting verbally or any other matter, your company is still required to follow the sexual harassment policy and investigate the claim. If you believe you've been subject to harassment, you are encouraged to complete the form. You may also make reports verbally. Anyone who witnesses or becomes aware of potential instances of harassment should report it to a supervisor, manager, or someone in authority. It can be uncomfortable and scary, but it's important to let coworkers know that it's not okay when you're uncomfortable about seeing what's happening in front of you. Remember, it's unlawful for an employer to retaliate against you for reporting instances of harassment. Anyone who engages in sexual harassment or retaliation will be subject to remedial and/or disciplinary action, up to and including termination. Your organization will investigate all reports, whether the information was given verbally or written. An investigation of any complaint will be commenced immediately and completed as soon as possible. The investigation will be kept as confidential as possible. Any employee may be required to cooperate as needed in the investigation. Remember, it is illegal for employees who participate in any investigation to be retaliated against. Your organization has a duty to take appropriate steps to ensure that harassment will not occur in the future. Here is how they will investigate the claims. An immediate review of the allegations will be conducted. They will take any interim actions as appropriate. Relevant documents, emails, or phone records will be requested. Interviews will be conducted with parties involved and witnesses. The investigation will be documented as is outlined in your sexual harassment policy. The individual who complained and the individuals accused are notified of the final determination and that appropriate administrative action has been taken. In addition to what we've already outlined, employees may also choose to pursue outside legal remedies. A complaint alleging violation of the human rights law may be followed with the DHR or in New York State Supreme Court. Complaints may be filed with DHR any time within 1 year of the alleged sexual harassment. You do not need to have an attorney to file. If an individual did not file at DHR, they can sue directly in state court under the human rights law within 3 years of the alleged sexual harassment. An individual may not file with DHR if they've already filed a human rights law complaint in state court. For more information on the DHR, you can visit www.dhr.ny.gov. An individual can also file with the EEOC anytime within 300 days from the alleged sexual harassment. Again, you do not need to have an attorney to file with the EEOC. A complaint must be filed with the EEOC before you can file in federal court. For more information on the EEOC, you can visit www.eeoc.gov. Note this though, if an individual files an administrative complaint with the DHR will automatically file the complaint with the EEOC in order to preserve the right to proceed in federal court. Many localities enforce laws protecting individuals from sexual harassment and discrimination. You should contact the county, city, or town to find out if such a law exists. Harassment may constitute a crime if it involves things like physical touching, coerced physical confinement, or coerced sex act. If this is the case, you should contact the local police department immediately. Workplace harassment can be based on other things and is not just about gender or inappropriate sexual behavior in the workplace. Any harassment or discrimination based on a protected characteristic is prohibited in the workplace and may lead to disciplinary action against the offender. Protected characteristics include age, race, creed, color, national origin, sexual orientation, military status, sex, disability, marital status, domestic violence victim status, gender identity, and criminal history. Much of the presented information in this training applies to all types of workplace harassment. Let's summarize everything we've covered and remember how important it is to take action when harassment occurs. As we wrap up this training, all employees should now understand the following: how to recognize harassment as inappropriate workplace behavior, the nature of sexual harassment. Harassment because of any protected characteristic is prohibited. Reasons why workplace harassment is employment discrimination. That all harassment should be reported, and managers and supervisors have a special responsibility for this. With this knowledge, all employees can achieve workplace behavior, avoid disciplinary action, know their rights, and feel secure that they are entitled to and can work in an atmosphere of respect for all people. You can find the complaint form in your